Wolf Theiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern, and Southeastern Europe.
Hello, everyone. Welcome to Wolf Theiss Soundshot Podcast, Digital Law Edition. My name is Katerina, and I'm a senior associate at the Wolf Theiss Prague office. I specialize mainly in e-commerce, intellectual property, and data privacy rights. I'll be joined by my colleague from Vienna, Adi. Adi is a counsel active in the IP IT field as well as advertising law matters. Adi has been advising on the DSA and its predecessor in Austria, the Communication Platforms Act, for quite some time now. Today, we'll be discussing the Digital Services Act, or DSA for short. Adi and I are very excited to have a chat about how this new legislation is reshaping the digital landscape and what it means for businesses of all sizes. The topic is really hot, as just on 17th February, the DSA regulation became fully applicable.
Thank you for the nice introduction and also a short hello from me. I'm also quite excited as this is my very first podcast. And so I'm happy to be able to discuss on one of my favorite topics of the last months or years, even the DSA. And the DSA is definitely a major overhaul in the online field. And I will take you on a short history lesson, but don't be afraid, it will not bore you with a long treatise on e-commerce law in the EU. But I think it helps to understand the importance and the significance of the Digital Services Act. So in the past, the major regulation in the online field was the e-commerce directive. And the e-commerce directive was negotiated in the last century. So at that time, we had, spam mail, and there was Napster to download music illegally. So that means you needed some basic rules on how to identify or mark commercial communication. And you needed some rules of how to address liability of a provider that itself did not publish this content. But, and that's important to know, back then there were no big players. Like, for example, there was Google and Amazon already on the market, but back then they were much smaller and did not have the relevance they have now. And for example, Meta, Twitter, YouTube, the e-commerce directive is older than all of them. So of course, the e-commerce directive was not able to consider all the issues, the new challenges that such services bring. And therefore, this means that the main legislation in the online field is more than 20 years old. And I think everybody is aware that 20 years in the digital age is a full epoch. It's a long time. So it was time to tackle the challenges that the users and businesses face today. But I think that was enough overview from a history perspective. And I think we should start with which services are covered by the DSA. In the past, the media coverage on the DSA has mainly focused on, the big platforms and how to, deal with hate in the internet and similar stuff. But in fact, the DSA is much broader because in essence, it covers all services that provide mere conduit, caching, and hosting. Those are quite technical terms, but in short, it covers service providers like, for example, internet access providers, wireless access providers, top-level domain registries, voice over IP services, content delivery networks, for those who cloud hosting services, online marketplaces, and many more. And what not everybody may be aware of, also specific functions often found on company websites can bring a company into the scope of the DSA. And these functions include, for example, comment sections, ratings, and reviews, and many more. And I think that Katerina, can you provide us with a little deep dive on this issue here, or this aspect?
Yeah, exactly. So, how do you know if the service you are providing actually falls within the DSA scope? Firstly, you need to ask yourself, does the service transmit information through communications network or provide access to that network? To put it simply, if you provide your users with the ability to communicate or message with each other, for instance, through an email or SMS function, then you may fall under the category of a mere conduit under the DSA. Secondly, does your service host information at the user's request? If so, you might be classified as a hosting service. There is a number of SaaS platforms or cloud services that host information on behalf of their users. Even if they don't disseminate or share the information, there are still some requirements applicable to them as intermediaries. Thirdly, consider if your service disseminates information to the public. If you are sharing content with potentially countless users at the user's request, you could fall under the DSA as an online platform. Lastly, if your platform facilitates consumer to trade contracts on a B2C forum, you qualify as an online marketplace, and that comes with its own set of obligations. Additionally, there are these specific functions that were already mentioned by Adi, like comment sections, rating and reviews, chat functions, and more. In a nutshell, when you are thinking about the DSA and if it really applies to you, you have to keep in mind the type of service you are providing. It is not necessary to assess the business as a whole. Instead, you should break down the DSA and evaluate it on a service-by-service basis. So there are some obligations that apply to all affected services. And Adi, would you tell us something more about these obligations?
Sure. So the few obligations that I will now explain apply regardless of whether you're an access provider or whether you have a commenting function or whether you're a big online platform or search engine. You have to comply with them regardless of how big your company is, except for one exception that I will show you later on. In essence, the rules that apply to all platforms cover two aspects. First, it should make it easier for the users and the authorities to contact platforms. In the past, this has been a major concern because it was sometimes quite difficult to get to the right person at a platform, for example. And the second group is rules for transparency. So one of the most important rules is that all service providers must designate single points of contact, namely a single point of contact for authorities and a single point of contact for the communication with users. And these have to be electronic contact points, for example, an email address. It is important that the service providers have to publish this information. In essence, that means that if you are a service provider, you will have to check on your website, in addition to all the obligations that you have under the e-commerce directive for publishing information, to also publish information easily accessible on where to find the single point of contact. Moreover, what some companies did in the past was, for example, to have some chatbot, but it was impossible to talk to a real person. So what the DSA also provides is that it is not sufficient that you provide only a communication function based solely on automated tools to make it easier for the users to contact and communicate with the platforms. For platforms outside of the EU, they even have to designate a legal representative in the EU where they offer services. And this will be quite interesting because this legal representative will have to ensure compliance with the Digital Services Act and can be fined in case of non-compliance. So it will be interesting to see who will take up these tasks for some companies that are far, far away outside the EU. But that's not all. In addition to this single point of contact, service providers will have to check their terms and conditions because the Digital Services Act requires them to introduce information on their content moderation practices. That means how they react, for example, to illegal content, to takedown requests, and similar stuff. So while big platforms already have, all these guidelines in place, a lot of smaller companies will probably not have. In addition, there are transparency obligations. For example, you have to provide an annual report, usually on your website because you have to publish it, which content moderation activities have been undertaken. For example, how many takedown orders you have received from an authority. And this may also include information on how many reports you got from trusted flaggers and similar. In practice, this means that the service providers will have to check whether their internal setup, their internal system, even allows to draw and collect this data that has to be published once a year, or for very large online platforms twice a year. But here's some good news for micro and small enterprises. They do not have to publish the transparency reports unless they are very large online platforms or very large online search engines, but usually this is not a very realistic scenario. So those were about the obligations that apply to all service providers. And Katerina, maybe you guide us through additional obligations for host providers.
I'll be happy to. One of the critical new obligations for the hosting provider is the implementation of notice and action mechanisms. This means that hosting providers must establish user-friendly mechanisms allowing users and third parties to report illegal content online. Upon receiving a notice, the service provider must promptly confirm receipt and follow up with the user on the decision undertaken, as well as inform the user about the possibilities for redress. Besides, hosting providers are required to provide clear and specific explanations whenever they take action against user accounts or content. These are known as statements of reasons. Transparency is key here, ensuring users understand the basis for any restrictions imposed. Lastly, when a hosting provider becomes aware of any information suggesting a criminal offense involving a threat to life or safety of persons, they must notify the competent authorities without delay. In a sense, these obligations aim to foster a safer and more accountable online environment. Are there any additional obligations that would apply to online platforms?
Online platforms that are host providers that do not only store content information, but also allow dissemination and publication of this information. And for those, there are additional rules. As Katerina previously already noted, if this dissemination, however, is only an ancillary function, then the service provider does not qualify as online platform, but just has to comply with the obligations for a host provider. So the recitals mention, for example, online newspapers with a comment section as an example for such a host provider that would normally be an online platform, but because it's just an ancillary function, only the host provider obligations apply. I consider this quite an interesting example because there are a lot of newspapers, online newspapers, where the commenting sections are a main driver of traffic to such websites, and it will be interesting to see whether this exception also applies to such online newspapers. But what are the additional obligations? Well, in addition to providing for a takedown system, as Katerina explained for host providers, online platforms also have to provide some kind of review system, complaint handling system, such like an appeal against the decision that the company, the provider takes in reaction to a takedown request. That means that they will have to implement some system that allows users to challenge a decision. And the important thing, they must do that for a period of 6 months. So they will have to establish a system that allows such appeals within quite a long period, actually. What's also important is it is not sufficient that a decision on such a complaint is made solely by automated means. So there must be some kind of human supervision, human review in case of such appeal decisions. What's also quite interesting and new is that online platform providers must suspend for a certain time period the services for certain users, namely such users that frequently post manifestly illegal content. So if you have somebody that frequently posts copyrighted material without a license, for example, the platform would be obliged to suspend service for this user for some time. On the other side, if you have users that frequently report content and file takedown notices that are not founded, that are manifestly unfounded, also such user can be suspended, or it can be suspended the possibility that he files further takedown requests. Again, this brings some new obligations to update the terms and conditions, because the conditions for such a process must be outlined in the terms and conditions, and there must even be examples being given what constitutes a misuse or an abuse of the platform or the takedown reporting system. Moreover, platform providers have to design their interfaces, meaning their websites or apps or whatever, in a way that does not try to shape users' behavior in a particular way. It's called, these dark patterns, or must not use some other kind of deceitful or manipulative manner in their design. I think you know what I mean when you think of the design of cookie banners, where you have one bright green button for accept, and then another one in a barely readable light gray, merging with the background with decline on it. So such nudging techniques are not allowed under the DSA. There are a few more, but I will now hand over to Katarina for the other obligations of online platforms.
So, online platforms are also now required to step up their game in advertising transparency. This means they must clearly label online ads and reveal information about their source and funding. Additionally, they must disclose main parameters of the targeted advertisement. Importantly, targeted ads based on profiling using special categories of data are prohibited. As for recommender systems, platforms must now disclose the main parameters driving their recommendations, offering users insight into why certain content is suggested to them. Users should also have the ability to influence or adjust these parameters according to their preferences. Another priority under the DSA includes online protection of minors. Platforms will have to redesign their systems to ensure a high level of privacy, security, and safety of minors. Notably, targeted ads based on profiling using minors' personal data are totally off limits. Are there any obligations that apply to online marketplaces, Adi?
Yes, sure, Katerina. I think it's important to know that the Digital Services Act is not just a consumer protection regulation, but applies to all and protects all users of intermediary services. But there are special rules for providers of online marketplaces, meaning providers that allow other companies to sell and offer products or services. And for such providers of online marketplaces that allow business to customer distance contracts, so the B2C online marketplaces, there is an obligation to KYBC, so know your business customers. So we as attorneys at law know your client. Banks have such obligations, but now also such platforms have to ensure that new traders offering products or services to consumers in the EU are really who they say they are, in essence. Even for existing traders, such providers of B2C marketplaces will have to use best efforts to conduct such business customer checks within 12 months now. In addition, there are a lot of obligations for e-commerce sellers based on pre-contractual obligations, information obligations that they have to comply with. And the platform operator now has to make sure and design their online interfaces or their websites, their apps in a way that their traders can comply with such obligations. In addition, the providers will also have to check databases, and they also will have to make random checks whether the products offered are illegal. So there are additional obligations for these online platforms. And what I consider very interesting is a new obligation that provides that if such a B2C online marketplace becomes aware that an illegal product or service has been offered through its services, the provider must inform the consumers who purchased such product and disclose the identity of the trader to the consumer. This is quite interesting because it means a proactive obligation to notify the consumer. And if you do not know the specific consumer, the platforms will have to publish the respective information on their websites. So you probably know that from, if you go to the supermarket and you are at the cashier, there you see this information that you should not eat this product because there are stones, glass, or something else in it. This is now transferred into the online field. So you can see there all these aims at making the online environment safer, but at the same time, it imposes additional burdens on the operators, which means that they will have to probably make some investments and incur additional costs to update all their systems, their terms and conditions and informations. But good news again, for micro and small enterprises, those rules do not apply. So, and then there's this very special category of online platforms. Maybe Katerina, you can provide a very short excursus to very large online platforms and very large online search engines.
When it comes to very large online platforms and search engines, much stricter rules apply. The very large online platforms and search engines are platforms designated by the European Commission, which have more than 45 million active users per month. The European Commission consider the key role they play in e-commerce, in disseminating information, in facilitating the exchange of opinions and ideas in European society. Some of the additional DSA requirements applicable for such very large online platforms and search engines would include an obligation to establish mitigation plans, which are actually subject to audits, which must address systemic risks like disinformation, electoral manipulation, cyber violence against women, or abuse of minors. Then, the very large online platforms and search engines must share data with researchers and authorities. Finally, the users may now decide if they wish to receive personalized recommendations and, if so, how, meaning recommendations won't solely rely on their online searches. The DSA became fully applicable to these very large online platforms and search engines on 25th August 2023, so I guess there is no need to dive into details here. And Adi will now explain who will supervise these obligations.
Yes, already under the e-commerce directive, there was the so-called country of origin principle, and this country of origin principle is untouched by the DSA in essence. So who will check compliance and impose sanctions under the DSA? Well, as a basic rule, for providers in the EU, it will be one or more authority in the respective member states where they are established. For example, for Austria, Austria will be the authority that will check whether Austrian service providers or service providers established in Austria will comply with the DSA. And if not, they will have the power to impose sanctions and fines on such providers. For very large online platforms and very large online search engines, there is a special competence for the European Commission, as in the past we have seen it, for example, in data privacy law. It was recognized by the Commission that it may not be a very good idea to give the sole powers for enforcing such a regulation to only one member state. What does it mean for the service provider? Well, for the service providers, it means that it might make sense to check the websites of the competent authority in their respective member state, because they may provide on the website information on what the focus of the authority is. They may provide some additional information that will show the service providers what currently is the focus for enforcement, for example, or what is very important for the company. Of course, this will differ from country to country, and there will be authorities that will give away information more freely, and other competent authorities that probably do not present a lot of information on their website. Katerina, I think that's quite one of the most interesting parts. What are the companies that do not comply with the Digital Services Act facing?
Yeah, before I dive into the sanctions, I would like to maybe add that in the Czech Republic, a Czech telecommunication office was designated as the supervising authority. It seems to be the office that actually gets everything. If the Czech Republic does not know who to assign a particular job when it comes to regulation on EU level, it's usually the Czech telecommunication office. So we will see how they manage all of these additional works. There is a full set of investigative and sanctioning measures that can be taken by national authorities as well as the Commission to enforce the DSA. And if you believe that the penalties for GDPR violations are tough, which is up to 4% of global annual turnover, we should brace ourselves for the DSA. Violations could lead to fines up to 6% of global annual turnover. A fine can also be imposed up to 1% of the provider's annual turnover for violations such as misleading the authorities, providing incorrect or incomplete information, or failure to tolerate an inspection from the authority. Additionally, there are periodic penalties up to 5% of the average daily worldwide turnover, which may be applied for each day of delay in complying with imposed remedies, interim measures, or commitments. It is for sure good to keep in mind that the sanctions are harsh. Adi, can the providers be also ordered to take certain measures to address the breach, or is it just the monetary fines?
Well, besides some orders by the authorities, I think one very interesting aspect is, in particular in countries where, for example, an authority is not that active, that there are also possible civil law measures, because the DSA explicitly provides that the users have the right to seek compensation from providers of intermediate services in respect to any damage or loss suffered due to non-compliance of the provider under the DSA. So while these damage law rules will mainly be based on national tort law provisions, the member states will have to make sure that this provision for damages is effective. So also non-compliance can mean that you are facing damage claims by users. In addition, for example, in Austria, violations of the Digital Services Act may also be asserted by competitors or certain chambers or associations under unfair competition law. So beside the strict regime that allows imposition of fines by authorities, you should also keep in mind that there might be some civil law liabilities if you're non-compliant. So beside the fact that actually all companies and probably all of us should give their best to make the online environment a little bit more safer place, there are also good motivators from a financial perspective and a business perspective for compliance. So it might make sense if you have any anchor point of being or any indications for being internet service provider. For example, if you have a commenting section on your website, for example, if you allow user interaction on your website or in your service, it might make sense to take a look on all the obligations under the Digital Services Act. Katerina, any further or final words on the Digital Services Act?
I would maybe add that also the interim measures can be actually imposed by the authorities upon the companies, like changes to recommender systems, increased monitoring or specific keywords or hashtags. There may be orders to terminate or remedy alleged infringements, and all this can be actually supervised for some time by the authority. So what does all this mean for online businesses from practical point of view? What do they do now? Well, for starters, it means adapting to a new regulatory landscape. Companies need to invest in resources and technologies to meet compliance requirements, which could impact their operational processes and bottom line. Since the stakes are really high because of the hefty fines and damage to reputation, it is important to focus on this. In conclusion, the Digital Services Act represents a shift in digital regulation with far-reaching implications for digital services offered to users within the European Union. By expanding its scope to include a broader range of digital services and focusing also on key functions, the DSA aims to create a safer and more trustworthy online environment for all users. Thank you for joining us today as we explored the Digital Services Act and its implications for businesses. We hope you found our discussion insightful. Until next time, take care and stay tuned for another topic, which would be artificial intelligence, discussed by our colleagues Jakub and Philip.
Thank you for joining us for today's episode of Wolf Theiss Soundshot. For more information, you can contact us via email at soundshot@wolftheiss.com or visit our website at www.wolftheiss.com.